several news articles outlining what the mayor did during that time period. She declared emergency declarations for both events. She shut down every business in the city at one point. She declared a curfew, citywide curfew during the riot. These are extraordinary executive powers.
All rise. Second Judicial District Court of the State of Nevada is now in session. The Honorable Connie Steinheimer presiding.
Water. Thank you. Please be seated. Good afternoon. Good morning.
Good morning.
This is the time set for case number CB 22-00560. I would appreciate if everyone would make their appearances. The petition was filed by the city attorney. I understand the city attorney is not an advocate, but the city attorney is the petitioner. So, Mr. Hall, you are here.
Good morning, Your Honor. Karl
Good
Hall.
morning.
Yes.
And you may be called upon through the proceedings. I just want to warn you.
All right.
Thank you. Counsel, for the real party in interest, I think we should start with.
Your Honor, William Mantle, Procurer.
Okay.
And good morning, Your Honor, John Marshall and Ruth Busby for Councilwoman Brekhus.
Good morning. So, counsel, it's my understanding that there's several issues right now today. One is there was a motion to dismiss that was filed as sort of an emergency motion, but I think that is still an issue. The issues raised in the motion to dismiss were relating to timeliness of the objection and jurisdiction. And then there's the substantive issue that is before the court. So, Mr. Marshall, are you ready to proceed?
Yes, Your Honor. We also have a small housekeeping issue regarding the exhibits, which we can address now or at the end.
Fine to do it now.
I think from our perspective, we'd like to move all exhibits into evidence, both attached to the motion and that were submitted by us on behalf of Mrs. Brekhus for the actual merits of the petition.
Okay, so are you suggesting though that all exhibits that were filed either with the original petition for the order to show cause or the opposition to the motion to dismiss or the motion to dismiss, all should be admitted?
And the supplement for the city file.
Okay, and the supplement for the city file should all be admitted. And is there any objection from the city?
No objection.
Mr. Mantle?
No objection.
Okay, then those exhibits are admitted.
Your Honor is correct that there are basically two issues before the court, and that is whether or not the court has jurisdiction, and second, whether or not the challenge has been heard. And so I'm going to address the jurisdiction issue, the statute of limitations, and Mr. Busby will address the merits of the constitutional provision of portability to the Brekhus situation.
Okay,
Okay?
that's fine.
We have a lovely PowerPoint here that will aid us. I think your screens are set up so
I think so.
I think without a doubt, and this is the latest position from the city, that Chapter 293C controls, and it's applicable to municipal city elections. And what that means is that the time frame set forth in 293C is what applies. And what we'd like to do is just quickly go through how those time frames work and how we get to the magic date, which is Monday, March 28th, as the last day to file a challenge. This is set forth in our motion. But really it involves three provisions of NRS 293C, 186.1, 195, and 175.2B. And those are listed up in the left-hand corner with the different colored X's. And just to work backwards, you work from the date that the candidate can declare and file a their candidacy. And that has some strange wording, but it's the first, starting with the first Monday and running through 2 successive Fridays. So in March 2022, it starts on the 7th and ends on the 18th. And that's the period of time in which a candidate has to file. And that's Chapter 293C, Section 175 to the red X's. Then we get to the date with which a candidate can withdraw. And that's because a challenge has to be filed within 5 days of the last date a candidate can withdraw. And again, it's very clear that NRS Section 293C, 195 provides 2 working days so not counting Saturdays, Sundays, holidays, etc. So those are the blue X's, and that gets you to the next 2 days, working days, which is the 21st and the 22nd. Then we apply the statutory time period of 186.1 that provides a potential challenger with 5 days to file a challenge. And or not most importantly, but interestingly, that deadline is not working days, it's just 5 days. And so those are the green X's. So 186 is the green X, those 5 days, and that brings you to Sunday the 27th. So we roll over to Monday the 28th, and that's the last day to file a challenge under NRS 293C 186.
And so your interpretation of 293C is that if it does not specifically state judicial days or non-weekends and holidays, that in fact you do not count those, you count those days.
Well, I think it doesn't matter in this case, because even if you include the 2 days over the weekend, the challenge was still not timely. But it's an interesting question, Your Honor, because the statute, in 195 clearly states working days, i.e. no Saturdays, Sundays, holidays. Whereas the statutory provision in 186, the 5 days, does not. But again, it doesn't matter, because either it's the 28th or the 30th, or excuse me, the 29th. And so there's no dispute that Mr. Mantle's objection was filed on the 4th of April, outside the statutory time period. So as we set forth in our motion, that's the end of the story. The court doesn't have jurisdiction because there's not a timely complaint for the city attorney to review in order to file a petition. So the court lacks jurisdiction over this challenge at the outset. Now, how did we get here? If it's so clear that 195 provides the 2 days. And that's because there's a separate statute, 293, Chapter 293, which provides, I believe it's in 202, a 7-day time period for elections and withdrawals under Chapter 293. However, that is not applicable here. So the question is there anything that could have happened that somehow allows a late challenge to be heard? And I'd just like to run through, because he relies on it so heavily, I'd like to run through the application packet and how one, this is essentially the welcoming packet that a candidate, Mr. Mantle's a candidate for mayor, so he got a packet, and that's part of, some of it is part of the city's exhibits and some of it is part of his exhibits. The one document they left out, we included as Exhibit 13. But fundamentally, it the opening letter, the welcoming letter from the clerk, the city clerk, includes this reference to the notice of completion of campaign. And that document is included within the packet that was received. And this, you'll notice in the highlighted section, this is Brekhus Exhibit 13, is that it distinctly identifies two different ways that you can withdraw. In that first highlighted section, it includes a reference to 293 and then 293C, section 195. So this was in possession, Mr. Mantle's possession, when he was going through his processing of when should I file this appeal.
So why would 293 apply?
Because, let me go back, this is a Secretary of State form.
Right?
Right.
Which is some of the problem, right?
Correct. So
But doesn't
Secretary
it
of State,
say that here you are, candidate for city council, you can withdraw either under 293 or 293C? So
no,
what does 293 apply to the city council?
it doesn't. So I don't read that as you can do either. And if I said that, I misspoke. This is the two sections in which withdrawal can happen.
Yes.
And this form was provided. And so it's either one. You can only withdraw under one or the other. And so
I understand.
it's both. But this, so then if you go on to the candidate withdrawal form, it clearly says this is for NRS 293, not for 293C. So this is what the clerk provided to all candidates for their withdrawal. And unfortunately, it's the wrong one. The question is, does that have any legal significance? We don't think it does, not only because the reference to 195, 293C, 195 was in Mr. Mantle's possession, but when he filed his complaint, eventually with the city on the 4th, there's another reference to 293C. And if you follow that reference, you of course get to 293C 186, which in the lovely version that's online, courtesy of LCP, it's hyperlinked to 293C, 195, and you get there, and that gets you to the two days. And at that point, there should have been a realization that it was either too late, or for our purposes, it confirms that from that point forward, Mr. Mantle's, we believe, challenge to Ms. Brekhus was late and it was frivolously maintained. We can talk about that at the back end of this hearing. And so, for our purposes, what, I think going back to the calendar, the only question that this court, I think, has before it is there some reason why the statute of limitation that expressly applies to this case shouldn't be applied. And the only thing that Mr. Mantle has brought up is the fact that the city clerk gave him a letter that had the wrong statute applicable to the mayoral race or any city municipal races with it. And does that operate to somehow vitiate the state statute? Otherwise, we couldn't find a case that says the advice of a city functionary or city official is able to change the law that applies to this particular challenge. So, and let's also be clear as a final note from me that Mr. Mantle didn't begin filing his challenges with either Washoe County or the city until the 4th. April 4th, so already the time had expired. So he had previously, I think on the 17th, if I'm correct, went to the the Attorney General's office
On the 18th.
on the 18th.
That's the record I have.
Yeah. And he picked the wrong forum to go to for a municipal election. And the question is, does that somehow save, does his mistake somehow save, avoid the possibility of the statute of limitations? And again, we couldn't find, the fact that somebody made a mistake on where they should file their document as somehow trumping the actual provisions of state law.
So do you contest the factual argument that the Secretary of State accepted that challenge, told him that they were working on it, and then didn't notify him until after the deadline that he had to file? And when they did notify him, they told him to file in the wrong place, told him to go to the county, and then he ultimately got to the city, I guess. I don't know. I don't have any record of how he got his complaint from the city, from the county to ultimately to the city. But is there any contesting that, in fact, there's some emails and letters that were part of the exhibits that showed that the Secretary of State was kind of told him, yes, you filed your complaint, we've got it, we're working on it, and then called him and said, no, you put it in the wrong place, send it over?
No, we don't contest those facts. We contest whether they're relevant
Right.
to this challenge. Because what you're articulating is some kind of estoppel.
Perhaps.
But who does that run against? Because there's no representation made by Ms. Brekhus, the critical interested party, the respondent, that there's a wrong date and therefore she should be stopped from asserting the statute of limitations, which is, I think, how you need to look at the facts.
I mean, it's possible to look at.
But the problem is the estoppel would run to the Secretary of State, if anybody, as to asserting that they couldn't then, they made representations that they couldn't move away from. But here, that the Secretary of State is not asserting any sort of claim that it is timely or untimely. And also remember that the Secretary of State, I think, addresses a large number of elections and election issues. So they have a form that you can fill out, and it's not, I don't think it's reasonable to conclude from them accepting a simple complaint that they somehow, that operates to extend an otherwise applicable statute of limitations.
I don't think that's the legal basis. It isn't extending it. It's whether or not the failure to comply is somehow excused or allows the court to find substantial compliance for some reason.
Your Honor, I think that would essentially open up a can of worms that if you file, what you're getting to is if you file someplace for something that's somewhat related, all of a sudden the other statute of limitations don't apply.
Well, certainly that would be an extension that would be, in my opinion, improper. But we have a unique set of circumstances here where the candidates were provided information and were provided information that they should go and follow the Secretary of State's website. And candidate did do that, followed it, ultimately filed the complaint in your calculations was filed late. And then we also have the added component that the city attorney reviewed those filings and filed a petition that he had found probable cause that this court should hear the case. So I don't know what he was using for counting, but certainly in his determination of probable cause, he found a basis to either discount the counting dates or overlooked it. I don't know.
We'll leave that for Mr. Hall to respond to. But the question for Ms. Brekhus is whether or not that makes a difference to the challenge that, and I would say for the most part, what the petition doesn't review, or at least from our read, didn't review whether or not the petition was timely. If anything, it just cited the constitutional provision regarding term limits and then several cases associated with that. It made no determination as to the timing.
Well, in order to find probable cause that this court should hear it, there is implicit in that a determination that this court has jurisdiction.
Yes, I would say that it's implicit that the city attorney was following what the city clerk thought to be the law.
Right.
I think we can agree that the city clerk thought that 7 days applied because that's what the Secretary of State's form says for chapter 293. Unfortunately, that's just wrong, it's an error. And so
Right.
where does the consequence of that error fall? And I think in our, we'll hear from Mr. Busby that there is a strong and provision cited by the Nevada State Supreme Court that when you come to these situations, you err on the side of eligibility rather than kicking people off the ballot. And so that's
That's a substantive argument here.
well, no, I mean, that has to do, I think it also applies here. If you're looking at where do the equities fall? You know, no fault of her own, a late challenge is, you know, you're being asked to accept a late challenge based on some equitable factors. I'm just offering that as another point of how you might construe, if there is any ambiguity, how you might construe either the applicable statute or factual situation. And that I think there's Supreme Court guidance, there's Supreme Court guidance that indicates that you should find, you know, if there's ambiguity, a tentative construction would be that you find eligibility over non-eligibility.
And when we talk about the court making a decision about whether or not the strict compliance with the statute was met and could consider the case if it was not met, where do you factor in the judicial economy that would be created if I were to say, okay, no, I won't hear it substantively, I can't hear it substantively? Couldn't a writ be filed on the same grounds? And then aren't we back in the same place?
A very, very interesting question. I think one in which Mr. Lorton is very interested in the answer to. But what is, I think, you know, from our perspective, there is a time limit in which you can make a challenge. And that time limit is set in statute and those control. And if you don't file within those time periods, we think that you haven't exhausted your remedies. So therefore, you shouldn't be able to file a post-writ. And what's interesting about the Lorton case itself is I believe factually it was filed pre-opening of, you know, it was prior to actually the candidate filing period. So it was filed before.
Presumptively.
Yeah. Which, you know, has its own oddness, but I think it is critical. And I'll also point out in 293C 186(1), it specifically says who you file the complaint with. It doesn't say the complaint shall be filed. It says to be filed with the city clerk. Because really, it's what you're trying to do is provide a short period of time for the city to get their ballot in order. Right? That's the kind of one of the fundamental interests here is that in order to print the ballot, these issues need to be resolved in a short period of time. And part of that is the clerks need to accept challenges, this process runs. And then either the court grants or denies, and either thing appears that it's not on the ballot. So that time period needs to be, I think there's an interest in sticking to those statutory timeframes that were set forth expressly in the section.
The argument that if you do not meet the statutory timeframes, you could not later file a writ may apply to Mr. Mantle, but will never apply to the community at large. Either if the person has been elected, there's a provision after the election, and there's a possibility for a writ, I believe, to challenge the constitutionality of the candidacy. Maybe not Mr. Mantle's complaint, but it isn't just a candidate that could challenge the constitutionality.
I think that's.
So I'm just talking about judicial economy.
Yeah.
Does it make sense based on all of that to get a ruling on whether or not it's constitutional for it to run?
Yeah, I would say, in one case, we have statute of limitations for a reason. And I don't think, with all respect, judicial economy is a reason why you can deviate from the plain statutory language. There's no argument here that 293C, 195, and 186 are unclear. Right? There's no room for while we can kind of say that it's really 7 days, or 2 looks like 7, or some other magic that could get you to the point where you would accept the 7 days as operative here. It's clear on its face, and so whether or not down the road some other person might file a challenge, I think we can speculate on that. But then we have to address that at the time that it's filed. But if it is possible, then that also undermines, I think, Mr. Mantle's other articulated defense here is that this issue needs to be resolved. There's probably lots of issues that are unresolved through the challenge process that nobody ever catches because they don't file or a challenge or not. So I think that the opposite value is that you apply the statutory language and there's a short time period that you make those challenges in order to get the ballot printed and ready to go for that primary election. Unless the court has additional questions, I'll turn it over to Mr. Busby to address the merits. I mean, we do think it's appropriate for you to rule on whether or not you have jurisdiction before you continue. But if you'd like to hear an argument all at once, we'll definitely bring that.
I do want to hear the argument all at once. I'm not sure what I'm going to decide with regard to jurisdiction. I think you've articulated it's important for this to be moved expeditiously. So we'll hear all of them.
Good morning, Your Honor.
Good morning.
I've got quite a few subtle points to get through, but I'll try and be brief. So, the substantive issue in this case is the interpretation of Article 15, Section 3 of the Nevada Constitution, which relates to eligibility for public office. It clearly states that a person shall be eligible only if they're a qualified elector. But from that point on, it gets a lot less clear. The statute, or the Constitution provision states that no person shall be elected to any state office who has served in that office, or at the expiration of their current term, if he is so serving, will have served 12 years or more, unless there's some other provision in the Constitution that would permit it. Okay, so what questions does this provision raise for some of its face? So what is at the expiration of the current term mean? The provision clearly assumes that the will have served provision at the expiration of the current term means that they're serving in the same office. And expire clearly means come to an end. It doesn't take into account whether the person could run for a different position in the same public body in the middle of their term. That's a brand new situation for the court. Brekhus's term as Ward 1 council rep will expire if she's elected mayor. If she's elected mayor, she'll take that position before her 12 years under the constitutional provision will be up. Now, there's two main cases that provide guidance as to what this provision means. First is Miller v. Brooke. The issue in that case was whether an individual who was elected to a term of office before the effective date of the amendment, but commenced serving in that office thereafter, was subject to the provision. So it's really not directly applicable to this case. And the court rules very clearly that the section means that if a person is served at the conclusion of their current term or will have served 12 years or more, they're not eligible. Now, that won't happen in Ms. Brekhus' case because if elected mayor, she will take office under the 12-year period. It will be 10 years. The next on-point case on this subject is Ward v. Jones, which is more clearly related, but still not applicable. The question in that case was whether an individual who has served 12 years or more as a council member is thereafter prohibited. And there were two real parties in interest in the case, Jessica Sesaraza and Dwight George. For both of these parties, at the time they would have taken office, the office of mayor, if elected, their 12-year timeline would have been up. So that is markedly different from Ms. Brekhus' situation. Again, if she takes office, it would be at 10 years, not 12. So even if the court determines the Brekhus should be excluded, which we don't think we should, the past 4 years have been instructed as to what a mayor can do and the powers that a mayor has. And in the Lorton v. Jones decision, there was a large focus on the role of the mayor vis-a-vis a member of the city council. The majority basically said that the Reno City Charter clearly demonstrates that the mayor's primary function relates to their duties on the city council. And the dissent largely focused on the kind of executive functions of the mayor's office. And what's changed since this decision was issued in 2014? Well, we had a riot and we had a pandemic. And during both of those events, the mayor of the City of Reno took a substantial role in asserting the powers, the extra powers, the executive powers of that office during this period. And those actions are illustrated in Exhibits 1 through 12. We would ask the court to review those. We'd ask that be admitted into the record. They contain several news articles outlining what the mayor did during that time period. She declared emergency declarations for both events. She shut down every business in the city at one point. She declared a curfew, a citywide curfew during the riot. These are extraordinary executive powers. These aren't just things that a member of the city council can do. And they make the point that was expressly made in the dissent in the Ward v. Jones decision that, and we're arguing for a good faith extension and modification of existing law on this point. We understand that this isn't it, but the historical experience of the city since the decision was issued by the Supreme Court has closely matched the concerns raised in the dissent for that case. But based on the fact that Ms. Brekhus will take office under 12-year period, and the court has never ruled on this issue, whether in the middle of a council person's term, they're under 12-year period. If they run for mayor and they're elected, are they allowed to take that office? The court, that's a brand new issue. And the Supreme Court has been very clear that the rules of statutory construction apply when interpreting constitutional provisions. And the rule of construction on this issue is that if there's ambiguity with respect to the provisions, they should be resolved in favor of eligibility to run for office. That being the case, the fact that there's no case on point dealing with a person who is running for the office of mayor, and they're a city council person, under the 12-year period listed in the constitutional provision, whether that person is eligible for office. We think this court, if it reaches that issue, if it decides not to rule in our favor on the motion to dismiss, that these statutory construction provisions as applied to constitutional provisions mean that the court should rule that she is eligible. And the burden should be on Mr. Mantle to prove otherwise. With that, I'm glad to answer your question.
Well, besides the fact that you want me to rule against the specific majority opinion in Norton versus Jones, I don't think I have any questions.
We're not asking for you to rule against the court. We're just, for the record, making that argument and illustrating the point that was made by the dissenters in that case. And we believe, based on just a pure, strict construction and statutory or the constitutional provision, that she's not going to, she will not have served 12 years at the expiration of her term if she's elected mayor. That's what it boils down to. And that if the court accepts that proposition is true, I believe the court must rule that she's eligible for office under Section 1 of Article 15 of Section 3.
Okay, thank you.
Thank you.
So, Mr. Mantle, you opposed the motion to dismiss, and this is the time you can come forward and come to the podium and tell me what you think I should do with regards to the motion to dismiss, and then you can move into your argument about the factual issues.
Thank you, Your Honor. Towards the motion to dismiss and the jurisdictional issue, I would like to state that it certainly was never my intent to cause any difficulty with the challenge. I believe that I exampled a good faith effort of trying to transmit and convey the challenge in an appropriate time. And I did take additional efforts to ensure that I was making that timely to the right place. The statute actually says the filing office doesn't specify that the Secretary of State, County Registrar, or Clerk sets the filing office. And my understanding was the filing office is ultimately the Secretary of State's office, as all of my expense reports must go there, and ultimately they have the authority over all elections within the state, which is why I went to them first and tried to clarify and ensure that that was the proper venue by taking it upon myself to contact them, as well as travel physically to Carson and speak with Sandy Edwards to that effect. And I was told everything was fine at that time, otherwise I would not have pursued further. They told me over the phone that the 4th was the last day to file the challenge. I was very clear that it was regarding Ms. Brekhus, and I even went there to clarify to make sure that we were talking about a mayoral candidate for the City of Reno. So, in that belief, in the faith of those government agents, I continued forward. One of the issues at hand that has not yet been discussed towards that jurisdiction and my ability to file the challenge is that the city clerk has to, as she followed the regulations she chose to and swore that affidavit to, it gives a time frame of which you can only make a challenge. Unfortunately, there's a mutual exclusivity between what the respondent wishes would have happened and what the city clerk had happened. That it was impossible for me to file a challenge in the time frame they suggested to also conform with the challenge that I could legally file with the city clerk's office. There was no avenue for me to bring forth the challenge than to give it to the city clerk in a time frame that the city clerk would allow. I have no way around
I'm trying to understand exactly what
Sure.
you're saying. You're saying that because the city clerk followed a different time frame, you were somehow told that the city clerk would not accept a challenge?
that they can only
Earlier?
accept a challenge 5 days after the last day to withdraw candidacy. The candidacy that the clerk utilized was the 29th. They would not have accepted the challenge until after the 29th.
Were you told that, or is that?
That's what I understood upon filing my challenge, yes, in conversation with Ms. Smith.
Okay.
That's my primary argument to, I did everything I could within the allowable access to filing the challenge, to file that challenge. And I even presumptively filed it to the Secretary of State, similar to Mr. Ward, to expedite it as much as possible. I thought that was the proper venue and they were going to sit on it until the proper filing period, which is apparently what they did. which is why they called me on the 4th to say, oh, you need to actually go to the registrar. That was incorrect, of course. And the registrar told me I needed to go to the clerk to clarify how I got there. And then I went, and then the clerk told me to go to the city.
So the registrar told you to go to the county clerk.
No, the Secretary of State told me to go to the county clerk, and the clerk told me to go to the city.
Okay.
Just for clarifications.
That's what I figured happened.
That is exactly what happened.
I see. So, assuming that, let's say, I deny the request to dismiss, you can argue to me why I should preclude Ms. Brekhus, remove her from the ballot.
Absolutely. The Constitution is clear that this is a matter of eligibility. Eligibility is determined at the time of filing. If Ms. Brekhus would have chosen to resign from her office prior to filing, this also would not be an issue. She would have ended her term, and she could have filed, and she would have been at 10 years and continued on. She chose to ignore the eligibility requirements of the Constitution, file, and we find ourselves here today. Because I cannot assume that she will be elected mayor, such that somehow that obliterates her obligation to be a qualified elector. I don't believe that the court should act on what ifs and maybes. And at the time of eligibility, she was not eligible as I put forth my challenge. She can't become suddenly eligible because she acted after the period of eligibility is required to somehow change her start. Thank you.
Thank you. Mr. Hall.
Yes, ma'am.
So we all are here based on a petition filed by the City of Reno, indicating that the City of Reno attorney has found that there was probable cause for this court to hear the case. Can you give me some insight into the issue of timing or jurisdiction that may have been analyzed by your office?
With respect to the timing on the jurisdiction of the challenge, so we were not involved in providing the city clerk with information that would be then provided to any potential mayoral candidates or challenges. She was given information by the Secretary of State and relied on the information of the Secretary of State. So we weren't aware of this challenge until after they filed their motion. However, in regards to whether or not the court should deny this petition or refuse to entertain the petition based on the statute of limitations, our position is no, you should not grant the motion to dismiss the case of the statute of limitations violation. For two reasons. Number one, fairness would dictate that Mr. Mantle relied on the city clerk. The city clerk relied on the Secretary of State. There's confusion because there's differences in those 2 dates between NRS 293 and 293C. In addition, the court recognized that there is an issue of judicial economy. And when you look at NRS 293C 186, it refers, if you look at subsection 5, if at the hearing the court determines by preponderance of the evidence that the challenge is valid, but that the person otherwise fails to meet any qualifications required for the office pursuant to the Constitution or laws of the state, or if the person fails to appear at the hearing, the person is subject to provisions of NRS 293-2045, which I think the court was referencing. So when you go to 2045, subsection 3, the provisions of this section apply to any pre-election action brought to challenge a person who is a candidate for any office on the grounds that the person fails to meet any qualifications required for the office pursuant to the Constitution of the laws of the state. And so they can still seek declaratory relief, writ relief, or any other equitable relief. So this isn't the end of the hunt if you decided that this issue is barred by the statute of limitations. In addition, when we talk about constitutional violations, I would direct the court's attention to the City of Burnley versus the State of Nevada. And that's at 132 Nevada Advance Opinion number 4. There was a challenge to the seat tax by the City of Burnley, and there were some constitutional issues, and the Supreme Court there determined that the statute of limitations isn't applicable to constitutional violations. A constitutional violation must be addressed. The legislature cannot legislate away constitutional violations, and the statute of limitations therefore should not be a bar to you considering the underlying merits of Mr. Mantle's challenge. With respect to the merits of the challenge, simply I found that there was probable cause. At the end of Councilmember Brekhus' current term, she will have served 12 years. That's all you get under the Constitution. If she was elected, she would serve 14 years. So I believe this is an issue that needs to be determined by the court. Thank you.
Thank you, sir. Okay, Mr. Marshall.
I just wanted to touch on a couple of points related to the statute. And first, I want to make clear that the city clerk, there's no evidence in the record that the city clerk informed Mr. Mantle that he could not, that she would not accept a challenge that hadn't filed that. And I think you're trying to get a specific answer there. There is no evidence saying that she would have excluded him, which is a distinctly different situation in the argument. And it's clear under 293C 186 1 that you need to file your complaint with the city clerk. So that is absolutely crystal clear. I think Mr. Mantle indicated that it was the filing officer, the election officer, but the statute actually says the city clerk.
Which brought me to kind of an interesting question for you. I don't think the city clerk is available for anyone to file something on Sunday. So you argued that Sunday was the day, and I'm sure she would not have been available.
No, I think you roll over to the next available day that it's over, just like a statute of limitations or a court order. You roll over to the following Monday if it happened on a weekend. I think that's a reasonable to make. And so it's just speculative as to whether or not it would have been impossible to comply here. If you didn't try, I think it would be maybe a little bit of a different case. If we actually tried to file a complaint on time and it was rejected, then we would be here looking as to whether or not, that's a different question than whether or not he chose to go to the Secretary of State when the statute clearly directs you to go to the City Council. And should that error excuse the otherwise applicable statute of limitations? And that's all that I have.
Did you want to address the issue of constitutionality not being barred by a time limit set by the legislature?
I think, fundamentally, I think that's in, and I'm not familiar with the case, which was not cited in the papers, as I remember. But I would caution the court, and we can provide the judicial review if we like, to rely on particularly tax cases and whether or not, an individual has the ability to challenge a taxation issue. There are timelines for constitutional challenges throughout statutes. I mean, you can't bring, timelines for Section 1983 actions, for example. There's deadlines. There could have been a statute, there could have been a violation of your constitutional rights that you can't seek a remedy to because you have not brought your claim timely. So that I doubt that the case actually stands for the proposition cited, which is all jurisdictions are subject to no statute of limitations if they violated some of these constitutional rights.
Well, we're not talking about an individual right in this case. This isn't an individual right case.
Well,
unless we talk about it as being Ms. Brekhus' right to run.
I think that is in the case that we cite it's in the footnote in the Burke case, I think it does recognize it as an important right to participate in government. But I think that I don't see why individual rights associated with either your civil rights under the First 10 Amendments or something versus a constitutional, state constitutional provision. Otherwise, why would we have the statute of limitations being there in the first place? I mean, I think you're assuming, therefore, that the legislature could not, I think Mr. Hall's argument essentially is saying the legislature could not pass a law that restricted the time for resolution by complaint of those constitutional issues. I think that is the earth-shattering position.
I agree that maybe that argument is a bit, the way you stated it might be a bit further than the case that was cited or applied. The difference between individual constitutional actions is that the individual is asking for a remedy, and that remedy is not, don't abuse me anymore. It is whether or not you can receive a monetary payment, you can be removed, something different could be happening to you personally. So those are personal remedies that we're talking about that are 1984 actions, correct?
Yeah, I think generally, but I don't think it's limited to purely remedial in terms of like damages. I think there are also equitable remedies that, jurisdictions can take. But I think that there's a difference. I think what you're articulating is a difference between an ongoing violation versus, one that, like, for example, this eligibility determination, and it's being brought by an individual here, not by, for example, in the Burke case, which was the Secretary of State himself brought that action. So what you have here is an individual filing a challenge to someone else's eligibility. And I think that does not raise the question, if there is one that Mr. Hall was trying to articulate, saying that there shouldn't be any limitation on the legislature's ability to prescribe time periods, however short, for trying to resolve those questions in a timely fashion. Otherwise, those challenges can be brought any time, which I don't think is what either the case or the legislature intended by providing a very short time period here in which to have those challenges filed with the city clerk, not with the Secretary of State, and then resolved in an expeditious manner, indicated by its direction of the court to place this in advance of all matters. So that's the only, unless you have further questions?
No, I don't think I do. Thank you, Mr.
Mr. Busby, did you have anything else?
Just for the record, I'd like to provide citations to the rules for statutory construction that we cited. First case is McKay versus Board of Supervisors, 102 NEB 644. And the second is Nevada Judges Association versus Lau, 112 NEB 51. And that's actually cited in footnote 39 of the Miller v. Burke case. And we're standing for the proposition that the right to hold office is valuable, should not be limited unless done so by clear provisions of law, implying that it's an individual right in some sense to hold office. And unless the court has any questions on the constitutional argument, hopefully we made it clear that there's any ambiguity there as to whether this would apply to someone in Mrs. Brekhus' particular circumstances, whether running for a separate office in the same public body under the 12-year period.
Do you want to address the argument made by Mr. Mantle, I think Mr. Mantle, that the role, or I guess you've argued it also, do you want to address again the role of the mayor versus city council? But Mr. Mantle argued that he would not have filed this challenge had Ms. Brekhus resigned her position as a member of the city council before she filed for mayor.
Your Honor, I think that actually makes our point for us. Because the argument is essentially under the constitutional provision that if she had resigned, her term would have expired before the 12-year period. So by Mr. Mantle's own logic,
if elected mayor, she will in effect resign that position before the 12-year period expires. Ergo, she's qualified under the same reasoning under the constitutional provision.
Thank you.
Thank you.
So, you have all provided interesting arguments that the court wants to look at. Clearly, I think you know I've read all your briefs and looked at all the exhibits, but I'd like to look at them in light of the arguments that you have placed. I believe at this point in the circumstance that I am not going to dismiss this case on procedural grounds, that I am going to rule on it substantively. And I understand the necessity to do that quickly and expeditiously so that the ballots can be printed and Ms. Brekhus can know where she's at in terms of this court's decision in case there's further litigation that's anticipated. And the same for you, Mr. Mantle. So I am going to take this under submission. I will prepare a written decision both as to the jurisdiction issue, whether or not I should grant the motion to dismiss, and or if I don't grant the motion to dismiss, the ruling on the substantive issue of the constitutionality of the candidacy. So I can't tell you exactly when that will come, but we will put it ahead of other matters and we will work on it. And we will notify you of the decision as soon as we have it. Does anyone have anything else for the court today?
Only if I may respond to the last comment of Ms.
Okay.
Busby. Your Honor, my logic was predicated upon eligibility requirements, that upon the time of filing, the end of filing, that an individual is eligible to run. If Ms. Brekhus, because she did not choose to resign, chose to potentially, depending on your decision, violate the Constitution by willfully seeking 12 years in her current office, she did not meet the eligibility requirements of filing for the same local governing body as stipulated. And additionally, I would state that the mayor has been asserted to be a part of that same local governing body because in most cases, if there's a city manager who handles most of the executions of the day-to-day administrative actions of a city, then the mayor is often considered to be part of that same local governing body. Now, if there was an abuse of power in terms of emergency issuances and whatnot, that's not for me to opine on. Thank you.
Was there anything further? Awesome.
No, Your Honor, thank you for the consideration. The only thing we wanted to ask is that our PowerPoint was essentially drawn from all the exhibits, but just in case we'd like to ask that our PowerPoint presentation be admitted, you can, I think we provided copies.
Do you have it on zip drive?
We can.
It doesn't look too long. You might even be able to email it.
Yes, I think we can email it to the clerk.
Okay, that would be fine. We'll take it and we'll mark, the clerk will mark it. The exhibits are all marked in an odd order because I've admitted them as they were admitted in the pleadings. So the clerk will just mark the PowerPoint in an alpha order as Exhibit A, so we'll know. I think you all did the numerical.
Yes, I think the city's, the city submitted Exhibit 5, I believe, which has numerical attachments to
Within
Exhibit
it.
5. Yes.
So I think we'll be fine if we just mark this as A. Or we'll do double A and then nobody will get confused.
Thank you.
Anything further? Okay, thank you. Court's in recess.
All rise.